Good morning, everyone. I'm Nora Sydow from the National Center for State Courts and have had the pleasure to work with the rapid response team since the beginning of COVID. A couple confessions, well, really just one. So this is the first time I've actually got to talk to live people in, I think, 15 months, so I'm really excited about it. It's a little awkward. But also during COVID, I also developed the serious need for reading glasses. So without them, I can't see my notes, but with them, you know, the awkwardness of like this and that. So this is the first time I'm going to try to navigate. So I'm going to try to wing it without the notes so I don't have to keep doing that. So bear with me. But I'm going to be brief because the really exciting content is sitting to my left. Thank you, Kathy, for the great introduction and some background. Again, the Conference of Chiefs and Conference of State Court Administrators, really at the beginning of COVID, so in March, I guess 15 or 16 months ago, established the Rapid Response Team. It's comprised of 3 Chief Justices and 3 State Court Administrators. We have met every week since then. I think this week is our 70th meeting. Worked really quickly and put together 6 working groups in different topic areas like criminal and civil and family to really start, throughout the 2020, pushing out tools and resources and deliverables to try to help courts navigate lots of newness, lots of change. And so that work, continued through the year, but then at the end of the year, we did a lot of reflection. Like Kathy said, I mean, we all saw so much innovation, strategies, things that we've been talking about in the court community for decades, but have been too scared, too afraid, too risk averse, what have you, to try. But COVID just threw us into it, and we really wanted to brainstorm and come up with a way to help court community, in this year, really push implementation to promote innovation, to prevent the backslide, to prevent, kind of going back to the business as usual. Just by show of hands, raise your hand if you cannot wait for your court to go back to business as usual and the old way of doing things before COVID. For those of you on the live stream, no one in the audience is raising their hands. So I think we're all on the same page, which is really good news. So that's when the Implementation Lab was, conceived. It was launched at the beginning of the year. The idea was we put out a kind of like a request for interested courts, a proposal. The idea was that courts across 11 different topic areas, I'm not going to read them, but they're on the screen, could apply. So these would be courts who you might be somewhere along the implementation continuum. You may have already implemented the innovation and you just want a little assistance evaluating it or maybe spreading it to other sites, or you may be very early in the stages of trying this. We wanted kind of courts in all of those places. We invited trial courts, appellate courts, AOCs, all were welcome to apply. We were a little nervous. We didn't really know what the bandwidth would be, given everything and how busy you all are with a global pandemic. But we received we have over 50 sites. We didn't have to turn anyone down, which was good. We have 22 states and 2 territories and 50 courts participating in these categories. They really got started in March. The idea was that we would create really a learning community, so courts who were trying these things and were probably at different phases of the implementation continuum could network and really learn from each other. It would be a mechanism or vehicle for the National Center for State Courts and our expert consultants to provide technical and tailored assistance for courts who needed some help. And we would also selfishly learn a lot about what you all were doing and be able to document it and share it, share all the lessons learned, what were the challenges, successes, et cetera, with everyone. So it's really a very fast-moving, quick project. We plan to wrap it all up by the end of the year. The courts, got started in March. They've been meeting, some have been meeting weekly, doing some webinars. Most are working on deliverables. We're looking at lots of different ways to push out information kind of in real time. This isn't a project that will just do its thing and at the end of the year we'll drop a final report. We really want to be able to provide to you all of the lessons learned, experiences, learn from our mistakes, don't try this, or this worked really well. So what we have for you today is a panel which will describe some of the local efforts, some examples from the field, and then also we have Chief Justice McCormack who will talk about judicial leadership and how judicial leaders can really work to sustain and spread innovations and prevent that backslide. So with that, I'm going to turn it over to Nicole Evans.
Good morning. So I'll give you some demographics. 54B District Court is located in East Lansing, Michigan, home of Michigan State. When in Spartan country, it's go green.
Go blue.
And we partner across the state with our colleagues. The district court itself handles municipal civil infractions as well as misdemeanors and felonies. Our court also handles parking citations. We are a 2-judge court with 23 employees. In March of 29, actually last week there was a headline in our local newspaper that read, "Why Michigan got walloped by COVID-19 and how it can prepare better for next time. In March of 2020, Michigan's governor declared a state of emergency and issued a stay home, stay safe order, which had all employees stay home and stay safe, except for the exception of frontline workers and essential workers. Our state court administrative office issued an administrative order declaring court workers and its courts and its personnel as essential workers. The administrative order also instructed the courts to implement emergency procedures. Now, the courts had to navigate how to protect the employees, the public, while maintaining accessible to the public. Our response was the virtual counter. The concept of the virtual counter came at 3 a.m., I'll be honest. And really it was just born out of the desire to remain accessible to the public while most of the operations in the state were shut down. The hours for the virtual counter were the same as the court's business hours, which are 9 a.m. to 12 p.m. And then as far as connecting with the court, we actually have a link that's right on our website. And as you can see, we use the Zoom platform. So court visitors can either use the link that will take them directly into our waiting room, or if they are having technical difficulties, Zoom has a phone option, which is also used. Now, before being admitted, there is a splash page. And on our splash page, we include information, the email addresses of all of our divisions. If anyone who has used Zoom or that customized waiting room, you know that this is prime real estate. We were very judicious because you only have 300 characters to work with. And so this actually is our splash page, which is live. The services that are available for our virtual counter are the same as if you were to walk up to our counter in person. You can make your payments, you can have your warrants canceled. If you need case information or updates, you can get that all with a clerk through our virtual counter. One of the nice features is that if there was an issue with non-public, which, you know, we'll get calls for record requests for non-public records, and you don't know who you're talking to, but with the virtual counter, that person can show their ID and prove who they are before you release that information. There's also an explanation of how to contest citations, as well as answer any questions or concerns. Now, during the pandemic, like most of you, we had clerks that were working from home. Now, prior to our work setup, we did not know how court clerks were going to be able to work from home. Our case management system is really hardbound and is on site and is secured. And so our IT department worked with us with providing equipment for our clerks, which consisted of a monitor and a computer, in order to operate the virtual counter. Once you enter the main session, you are greeted by a clerk who is happy to assist you. The internal logistics for how we I'm sorry, I didn't realize that screen was going to bounce like that. And this is actually the work clerks, Alex, so I'm just going to give a quick shout out to Alex for helping with this presentation and providing a picture of her at-home setup. So each day, the virtual host who's assigned, we have a schedule, so we have about 10 clerks who are managing the virtual counter from home. And we have it set up, and I let the clerks decide how they wanted to, and so we have 2 clerks per day, one who handles the morning shift and the other will handle the afternoon shift. And each day they log in just before 9 a.m. To host. And during the hosting session, they're basically the triage for any questions that come in. Sometimes we find ourselves needing to use the chat option. That picture is actually used as our face page for the virtual counter. So if you enter our virtual counter, that screenshot of the court is what you'll see. And as you can see, it's always sunny in East Lansing, Michigan. Some of the reasons that we use the chat option is, it's primarily, especially at the start of the day, that's when we typically handle our arraignments. And most people will come in saying, I don't know which judge I'm supposed to see. Can you give me the Zoom link? And we found we can drop that judge's Zoom link into that chat option, and the court user can click on that link and be taken automatically into that court sessions or in the waiting room of that court. So we find that to be very beneficial. Also, if there is a line, then we can notify the visitors that are in the waiting room that we will assist them shortly. And then there's just technical difficulties because, with technology, there's technical difficulties. And so we try to plan ahead for that and just allow people to use the chat option or just instruct them to call us back by phone. Sometimes we have to use the breakout rooms. Not very often. But when we're using the breakout rooms, it's used to reduce the wait time in line. Also, if the host, the scheduled host, is having received a question that is complex, they can bring in another clerk to assist. And then when that clerk joins the main session, then they're paired into a breakout room to assist that court customer. One tip for using breakout rooms, when you open them up for the day, make sure you plan ahead for however many you need, because once they're active, you can't add any more to that particular session. So here we are with our statistics, because you probably just want to know the numbers. And as you can see, the image that we use is really the end of a very successful virtual counter day. So from January through, and we had an update, so from January through June, so for the past 6 months, our court logged over 1,800 calls, nearly 1,900 calls. So we're averaging about 300 calls per month. And one thing that I can say is that the virtual counter, although the concept is simple, it really has made a big impact in how we engage with the community. It also provides a low-stress environment for court users who have different levels of comfort with technology. And so we use this as a way to sort of onboard and acclimate people prior to them having to appear before their court hearing, where you don't want someone at their court hearing struggling with technology while trying to manage their defense. And so by offering a virtual counter, then those court users can engage and be assisted and get familiar with all of the processes or features with Zoom, again, prior to showing up in court for their actual hearing. So the last thing that I want to say is that while the pandemic has exposed some of the ugly truths regarding disparities, it also has shown us what's possible. And as court managers, we need to focus on what's possible when we talk about conventional court processes. Reimagining how a court operates, I believe, is our duty. And making sure that we maintain accessibility to the public, access to judges and justice is our job, is our job. We can no longer be satisfied with the status quo, and that, I believe, is to be our new normal. Thank you for your time and attention.
Thank you, Nicole. It's sitting up on this stage with these amazing women and court leaders that I'm all too aware that as a consultant at the National Center for State Courts, it's because of courts like this. It's by virtue of the work that different courts are doing across the country under the pandemic conditions that I get to be up here. And that I get to tell you about a couple of the labs that Nora mentioned, specifically the Domestic Violence Lab and the Case Management Lab, and the courts that are participating in those, because they're doing some tremendous work. So first of all, with the Domestic Violence Lab, and I'll mention that I have no idea how to page forward. Do you know how to go forward on the PowerPoint?
Green.
Ah, thank you.
Or just ask them next slide.
Next slide, Anthony, if you would. So anyway, thank you. All right, and one more if we could. So on the app, in your materials, you have a couple of different documents that I would direct your attention to, because we tried to pack in there some different resources, links to different reports. There's some information about our dashboard workshop series that's been really exciting. So with regards to the Domestic Violence Lab, we have a number of different courts that are participating in that. We have Kansas, Massachusetts, DC, Arizona, Utah, Illinois, the U.S. Virgin Islands, North Carolina, and the Tulalip Tribes of Washington. And we also have representation from the Alliance of Tribal Coalitions to End Violence. And these courts and these people that are involved in the Domestic Violence Lab are working on some pretty hefty issues, like the issue of confidentiality. What does it look like when the courts translate to the virtual environment and there is a requirement that the dockets provide information about the type of proceedings? There are a number of courts where it's still a requirement that that be published on a protection order docket, that it say the names of the parties. There are even requirements that the parties' addresses be published. And that's a challenge if you are a person that is seeking protection and your address is being published on the World Wide Web. So these are some pretty significant issues that this group is dealing with. They intend to create a document that gives some practical considerations for courts that are working on virtual hearings. I think that many of us have heard about a case where the petitioner that was seeking a protection order was actually in the same home as the respondent, and the respondent was coaching her on all of her answers until the attorney said, Your Honor, I think that it seems to me that the petitioner and the respondent are in the same physical location. And so issues like that are the same that the Domestic Violence Lab is taking on. And so there will be that virtual hearings discussion guide, and then we're also going to have a guide that talks about interjurisdictional communications. And in this new world, in the virtual environment, how to ensure that our communications are as effective as possible. The other thing that I wanted to talk to you about is the Case Management Lab. And we have 5 jurisdictions there. Feel free to shout out if this represents your jurisdiction. But we have Fulton County, Georgia Juvenile Court. We have the state of Indiana. We have Webb County, Texas, and that's the court at law number 2. We have Marion Superior Court in Indiana, and we have the Philadelphia Court of Common Pleas. And these 5 different courts have very different goals. So some of them are taking a look at they're all working on the case flow management principles that you know and love that have been in place. And they're also trying to innovate new practices, and they're trying to draw from emerging knowledge about case management and some of the concepts like triage that judicial officers and court staff can, at the very first opportunity, lay eyes on the case, lay eyes on the parties, and determine what case characteristics point to what pathway so that those cases can be resolved with the right amount of resources at the right time. And I stole that shamelessly from Judge O'Grady from Johnson County because I love how he says that. There you are. So these courts are looking at different goals. They're looking at creating different workflow queues that can help route cases to the appropriate judge or judicial resource. They're looking at how their case management systems can flag them on the necessary events. It's interesting, 4 out of 5 of the courts that we're working with are actually taking a look at their time standards and the appropriateness of their time standards. And then, of course, much like you, all of these courts are taking a look at what to do with the backlog. And as cases start to accumulate, and the recognition that with these really sophisticated court case management systems that so many courts have now, we have maybe more data than we have ever had. And yet so many courts are saying, yet I don't have the information that I need that tells me how to prioritize the cases that need to be heard. And so, again, some pretty weighty issues that courts are working through. We recently, through the Case Flow Management Lab, we hosted a Build a Backlog Dashboard workshop series. And we're very much in the middle of it. And so if this is something that piques your interest, please let me know. Thank you. So what this is a picture of is the workshop that took place just last week. And what was exciting about it is that we had, from our initial workshop that was on May 4th, we had about 300 participants that signed up for the workshop, and they represented court teams. We were trying to encourage court teams to be composed of like a judicial officer, a technologist, and the business analysts, so that everybody could come around from their own unique perspective and talk about what's needed to look at backlog data. And so we have, 300 people around the Zoom room, and people are entering into the chat. And we had Oregon and Hawaii and Orange County and Wisconsin and Pennsylvania. We had all these different courts that came forward with the resources that they've either developed or that they're developing right now that help them manage cases. What's exciting about it is that it's the court community, and everybody shares their resources. And what we're looking forward to is, just promoting progress in whatever form that comes in. And if that's a court creating a storyboard or sort of a visualization of what they want their court management data dashboard to look like? Great. But the idea is that in September, by looking at examples of these different courts that have been able to implement some effective strategies, that we'll have some courts come forward in September and say, this is it. This may be rudimentary, but it's what we're using right now to help us focus on backlog. And it's movement like that that's exciting. And so from both from all of the different labs that Nora mentioned and that we're all involved in, we're looking forward to being able to produce for the national court community some lessons learned, and that it can be for the benefit of the courts within the states. And then I know that international courts are taking a look too. We had something like 20 participants from Trinidad and Tobago. It's a really progressive court. So they're good things that we're learning, and there's good progress that's being made. So I appreciate all of you and all of your efforts. Thanks.
Good morning, everyone here and online. It is a pleasure to get to visit with you. I'm so proud of what all of you have accomplished in the last 16 months-ish, and Michigan in particular. Nicole's 3 a.m. idea has made a tremendous difference for the people in her community, and not only in her community, because as soon as we heard about it, I dropped in on her virtual lab and watched her interacting with members of the public, and then we gave her more work and sent her on the road to teach other people in Michigan what she was up to so that other communities would have the benefit of Nicole's excellent 3 a.m. idea. And thank you, Nicole. This has been quite a period for courts. It was rough on judges, I'll say that, lots of judges. But it was rougher on you, because you did the hard work to make sure people could continue to access justice and be safe. And we know that. We know you had to figure out how to do the technological part of it. You had to teach your judges. You had to keep holding our hands. You had to make sure the public was confident that they were going to be safe and be able to continue to access justice. And we know you worked twice as hard as you already worked, and that was pretty hard. And I'm grateful for it. So thank you for everything you've done over the last 16 months. I've said this in a number of times in a number of rooms. COVID was not the disruption we wanted, but I believe that it might have been the disruption we needed, because I believe that we have learned so much about the systems we are running and what's possible, that we can come through this, if we keep our foot on the gas, with a fairer, more equitable, and better justice system. And it's going to be because of the work you've done and the work you're going to keep doing. The National Center has served this really important role. I've been really grateful to be part of the Rapid Response Team's technology post-pandemic planning something. I don't even remember the name of the title of the group that I'm a co-chair of with David Slayton from Texas. But we produced a lot of work products in that work group, and these innovation labs have been a tremendous way to harness all of the good ideas across the country, produce work products that then are available to others, so that we don't lose ground, so that we make sure that the progress we made is progress we keep and build on, and learn from one another. I've been proud that Michigan is involved in a number of the labs. The Eviction Diversion Lab has been a very exciting one. Michigan, like many states, put the entire state into an eviction diversion program last summer. And we've been able to be quite successful in diverting people from the eviction docket and getting them the resources they need that were provided by the federal government. The Eviction Diversion Lab has sort of crowdsourced all of the ideas that different jurisdictions have used for their diversion programs, because of course Michigan's rules and statutes don't map onto California's or Texas's, but we all have pieces of what we've done that are useful, and the Eviction Diversion Lab has put together this wonderful diagnostic tool, which that slide had up, which is sort of like a BuzzFeed quiz for diversion resources, so that jurisdictions that are still looking to put a diversion tool in place can do that, and can do it with the help and assistance of the excellent staff at the National Center. We also have been participating in the self-represented Litigant Lab. As you can see, we have people like Nicole figuring out incredible ways to help the public navigate their justice issues and stay safe. And I've been incredibly proud of that. The Remote Hearing Lab has some excellent work products that I would draw your attention to as well. They've been focusing largely on tech solutions for hybrid hearings. Hybrid hearings are going to be part of what we're doing going forward no matter what. I can't imagine how they are not. If we are having a hearing and there is somebody who could appear remotely but could not appear in person, I'm not sure how we could not figure out how to accommodate that person if they have young children, if they have a job, if they have some other reason that prevents them from getting to a courthouse and we can allow them to participate remotely. I'm not sure how we tell them no going forward. But the technological aspects of remote hearings can be tricky. How do you make a record when somebody's online and somebody else is in person? What are the best tech solutions for running those hybrid hearings? And the work products from that lab are quite useful, and we're going to continue producing those. The ideas behind the labs are to produce tools and resources that help us harness what we've learned. So I want to talk just for a moment about what I think is one of the most important resources for harnessing and building on what we learned, and that's leadership. Your leadership, as well as judicial leadership. But I believe that judicial leadership is only as good as the leadership of the folks in this room and online. Because you can help your judges who want to make a difference, or you could hurt them if you want. I know you don't, but you are the reason why we succeed when we do. We've had a lot of long-standing, significant issues that we've been talking about my entire career as a lawyer and a judge in our judicial system. Access to justice, for example, is something we've been talking about since I became a lawyer in 1991. My first job was as a legal aid lawyer in New York City. And despite excellent efforts, intentions by members of the bar and the bench and the public, and even collaboration among those, we haven't made significant progress on the number of people who have to navigate courts without lawyers in our communities. I don't know who, I just used the statistic last week and Chief Justice Heck told me whose line it was and I still can't remember. I think it was Jim Sandman's from Legal Services. This is a true number. Americans spend more money on Halloween costumes for their pets than we do on legal services for the poor. And we've been talking about it for a long time. What we've seen in the last 15 months is we can do things really differently. We're collecting data also in our National Center convening work. We've been speed dating, connecting courts and researchers to try and document some of the differences we know we've all seen. I hear from judges and court administrators across Michigan who say the default rates in misdemeanor cases, small criminal cases, are significantly lower when people have a remote option. There are fewer people that are going to have warrants. There are fewer people that are going to have to cycle through jail and figure out how to care for their family, even when those short jail stays are so disruptive. We know that in in-court eviction dockets, the number of people who never show up is significantly high. But in remote hearings, it flips. So we have all of a sudden learned that we have enormous new tools for addressing a problem we've been talking about for decades. And we're going to take advantage of it. At the same time we've been having this incredible change in our court system, we've also been having, in my experience, the most robust ground-up discussion of race in our justice system. People have been talking about race in our justice system for a long time, but in my view, not in the significant, robust, ground-up, public-involved way than we have in the last 14 months. It's not a coincidence that all this is happening at the same time. And it is not, of course, without consequence that some of the changes we are seeing are impacting the communities who have had the hardest time accessing justice as far as we can remember. Those are all important reasons for keeping our foot on the gas. Courts, I always say, only operate successfully when there is public confidence in what we do. We don't have an army, we don't have any money. All we have is the public's confidence in what we do. If the public doesn't think what we do is fair, because it's not fair, we're going to lose the public's confidence. We have an opportunity right now to keep our foot on the gas and take the progress we've made and take it even further. And we will come through this with a much fairer and more equitable justice system than ever before, and only because of the hard work you all have done and the hard work you're going to continue to do. So I want to finish where I started, which is to thank you for that and let you know that we are going to have some time for questions as well. So thank you all.
I think it's on, yep. Thank you, Chief, and thank you for reminding everyone what I forgot to, that we are going to be able to field questions. I understand, I think there's some podium mics, is that, or a roaming mic? We'll figure that out in a minute. But the last portion of this session, we wanted to, I think, have some follow-up questions and a little bit of a roundtable discussion among the panelists, but also allow you the opportunity to ask some questions. But I'm going to kick it off. I have a question for Nicole. We heard about the virtual counter that was, spurred by the COVID pandemic. But my question really is, what's next? As things are opening up and looking to post-pandemic, what's the future for the virtual counter, and how did you or how are you making those decisions about how to keep it in as part of your new normal?
At 3 a.m., I'll have my next ideal. One thing I want to stress about the virtual counter, and I'm not sure if that came across clearly, is really this is a simple concept. We are operating this counter with one Zoom Pro license, a computer, a competent and compassionate staff, and of course working Wi-Fi. So this is something that you can easily implement in your course, and it really depends on the type of court that you have. Like I've mentioned before, that my court is a smaller court, 2 judges, 21 employees, but I've seen it operate in larger courts because it can. You just really need to just dedicate the staff to operate. So what's next for us? Monday, our court, our staff returned, we reopened to the public. However, we maintain a hybrid working schedule, and that is because we found that we can operate pretty much a lot of things remotely. So by offering a hybrid schedule, it allows us to retain our staff. I'm sure courts across the nation are probably experiencing what we're experiencing, which is the talent dump. We have employees that are retiring or leaving, other jobs. To start off as a court clerk, I was told recently by my deputy that the pay or the starting range is equivalent to fast food. Okay, so we need to take a look at that, Chief Justice. We need to take a look at that because the work that we do, the work that our staff does is important. It's due process. And we need to make sure that our staff cares about what they're doing and cares about the public that they engage with to make sure that that due process is not disrupted. So next steps for us is really continuing the virtual counter setting in a hybrid work environment. I'll tell you that the schedule that we're operating on currently, because since the pandemic, everything is a beta test, right? So we are doing a 3-day work week on site. So we have a Monday through Wednesday group and a Wednesday through Friday group. And this sort of keeps in line with how we've been operating in cohorts for the past 16 months in trying to keep everyone safe and healthy. But now with the vaccinations and the restrictions being lifted, we wanted to give an incentive for our staff to continue to work. And also as a token of appreciation, because, budget-wise, it's not like, they're not in it for the money. So the least we can do is offer them the option to be able to work remotely.
Thanks, Nicole. My next question is for Ms. Davis. There's a lot of attention and focus and fear around the backlogs and the looming unknown nature of the backlog tsunami, at least in some case types. So I know there's a lot of interest in what the courts in the lab and in the workshops are working on, the Build a Backlog dashboard. What are you learning, or what have you seen in the participating courts? So this is like the small courts, or for those of you who think you don't have the resources, the technology, the expertise among your staff to really put together a big, fancy, robust dashboard. Are you seeing anything that might give them a glimmer of hope?
Thanks for that, Nora. Yeah, the big takeaway here is that Excel can be your best friend. And I can't take credit for that. That's Jeff Hall of Oregon. He's been a state court administrator. He's worked at the local level, and he knows about all of the capabilities of court data and the shortcomings. And was hearing, like I was, about courts saying, yeah, we've got this fantastic case management system, we've got great data, but when it comes down to figuring out which of the cases are really, that red alert category that need to be heard as soon as possible, and then how to sift through the caseload, that's a real challenge. And so through working in the Oregon Judicial Branch, their data department, they've developed a couple of tools, and one of them is Excel and one of them is PowerPoint. So I couldn't begin to describe to you how it all works. However, I can give you a link to a folder and to the lab the workshop that we conducted last week, where Jeff walks through it, and it's it's free. It doesn't cost anything. And the other thing that we're really trying to emphasize is that maybe it's Excel, maybe it's PowerPoint, and maybe you start to design a storyboard, you start to draw up your specifications of what you want a dashboard to look like going forward, because we could be in this for a while. Oh, thank you. Thanks, Nora. Yeah. And I also want to thank Adam Cohen of Hawaii, who took it upon himself, and I love this because he didn't know how to create a dashboard. He saw what the Court Statistics Project had put together with pandemic data from 12 different courts, and he said, well, I don't know how to do that, but he started watching YouTube videos, and he's a programmer by training, and so he taught himself how to create a dashboard based in R Shiny, and so that's a free resource. And that's also available within this folder of materials. It's in the materials that we included that are on the app, and it's truly something that he says that any court can take that and adapt that. So thank you for bringing that up.
Just a reminder, we can take questions. So I'm going to give you another couple minutes to think of some, but I'm going to toss one to the Chief. Chief Justice McCormack, the kind of the magic wand question. You as Chief come close to having a magic wand as probably anyone, but thinking about the innovations and the strategies that we've seen in the past 15 or 16 months, what have we not done yet? What have we not figured out or overcome moving forward? Maybe besides, you mentioned civil legal aid, we'll add that to the top of the list, racial injustice, but what else haven't we gotten to yet?
Well, first of all, I wish I had a magic wand, but I do not. I am one of 7, and that means I only have 1 vote of 7. It means nothing, the whole chief title. Let me just get that out there. I think there is a lot left to try, and we're in the mood to try, so I'll throw out some of my favorites. I would love to get to a place where we have transparent data about our civil and criminal justice systems. I think the public should know as much as there is to know about what's happening in our criminal and civil justice systems. And I would love to have transparent dashboard data about in every court across the state. It's complicated because, at least in Michigan, and I think in most places, criminal justice data and civil justice data is just hard to come by. There's, just a lot of data that hasn't yet been collected. There is discommunication between courts and the agencies that have some of the data that we need to be able to provide it in a way that's transparent. But if I could wave a magic wand, I would have transparent data for the public to see what's going on. The courts are the public's courts. I think they should know everything there is to know about them. I also think it would help us all make better decisions and better policies. I think we have to, and a couple states are doing this, Arizona and Utah, and a few more are looking at it. But we have to start thinking about who besides lawyers can help people with legal problems. Not every medical problem needs a surgeon. I don't know about you, but my nurse practitioner is way better than my doctor. She's the one I call when I really need help. Why do we not have people besides lawyers who can help the great number of people who have to either figure out how to navigate courts with their weird language and tricky rules, and when there are lots of legal problems for which we could train people to help and provide solutions. So re-regulation, deregulation, however you want to think about it, I think we have to think about non-lawyer navigators and community partners and helping people get resources to the justice system in new ways. We need a lot of innovation there. How much time do I have? I feel like we know so much now about the ways in which the justice system is ill-equipped to respond to mental health issues and substance abuse issues, but all behavioral health issues. Problem-solving courts are amazing. They do incredible work. Everybody should should be able to go to a problem-solving court, but they're incredibly resource-heavy, and that's just not the reality. So if we know there are things we're not good at, I think we should be partnering with whoever else is better at them and moving some of these solutions upstream. There are jurisdictions that are, and Detroit is soon to be one of them, locally at least, doing some innovative upstream things with mental health and substance abuse. I think we'll see much better outcomes if we do that. I think there's lots of room for innovation there. I could go on and on, but yeah, keep your foot on the gas.
Hi, excuse me. This is Roger Rand. I'm from the Oregon Judicial Department. I wanted to respond to the comment about our dashboards. I made me really nervous hearing that because I don't want Jeff Hall to get a bunch of emails about our free service. It's not free. So it's not PowerPoint and Excel. It's enterprise custom reports drawn from Tyler and Power BI. And Power BI is included in a level 5 Office 365 enterprise subscription. So it's free to Oregon because we have that subscription, but it's not free to everyone who does not have that subscription. So I just wanted to clarify that.
And I do appreciate that clarification. It was when we were specifically looking at if a court has no resources, how can you put that together? So thank you for that.
I think we have another question.
Hi, trying to figure out how we can keep the gains we have, because I'm very, I like what Nicole's saying about trying to move forward with helping our workforce, because yeah, a lot are underpaid and or not paid great, and we've enjoyed the hybrid approach, but I think the politicians at this point have the impression that the court has been closed for 16 months. We know that's not true. But what is the COSCA, what is the National Center doing to kind of combat that and let us keep these gains? Because I'm very afraid that we're all going to be shoved back in the courthouse when we really need to let the new workforce have a chance to have a little bit of a different way of doing things,
So it's a great question. What is COSCA and CCJ doing? I will say that in the post-pandemic technology planning committee, or whatever it's called, that I co-chair, we are working with, I mentioned briefly, matching courts with researchers to try and produce data to show the progress courts have made in this period. And there is also a workforce lab, I believe, that's crowdsourcing all of the policies that are responding to the concerns you raise, because it's impossible otherwise if Minnesota comes up with a great idea and you want to see it, you can't Google it. So the National Center is actually putting together a lot of those materials. But I will say that the Conference of Chief Justices is acutely aware of this concern. I've heard President/Chief Justice Hecht speak very eloquently recently, responding to the other branches of government saying the courts were shut down. And CCJ is taking it on pretty directly. I assume COSCA is as well. I have less information about COSCA. But it is absolutely an issue that we care about. We are meeting later this month, and there is I think a lot of the business is on this topic. I would say if you have good ideas for us, though, please don't be shy, because you're right. We have to figure out how to both communicate to the other branches of government that fund us and the public everything we've been doing, and support the folks who are making it all happen, in my view, working twice as hard for no more money. In fact, through most of 2020, we were all worried about who was going to get laid off. So just the opposite. I appreciate the question, and again, open for all kinds of ideas.
My question is a little different. It has to do with changing the philosophy of the black-robed humans. I'm one of them. She's one, so she can say so I can say this. I'm hearing I think, absurd amount of chatter from judges about we have to be in the courtroom to have hearings. And I'm hoping that your data can help us, just as it did years ago, come in with time standards that were adjusted to real-life ability to move cases and differential case management. I'm hoping that you're looking to making differential case management live or electronic a part of those standards, so that it becomes presumptive, for example, that things like abuse and neglect cases, which have 9,992 things for every mom to do and show up in court 4,000 times, can reduce our failure rate in unifying families by presumptively having those dispositional review hearings done by Zoom, and where the court would have to show good cause for why our convenience matters more than the convenience and ability of the people who own the courts.
Can I just say amen to that, or do I? Ladies and gentlemen, Judge Stevens from Michigan Court of Appeals. She's a tremendous leader in our state. I'm really glad she's here, and she's exactly right. That we have learned, again, right now, anecdotally, but we are quickly trying to collect data so that we can respond to the naysayers, that there are certain cases where it makes a tremendous difference in keeping a family together, in getting more participation. Not just abuse and neglect cases, a lot of probate cases. Every case where kids are involved it turns out the judges will tell you to a person that they're getting better information, better participation, more participation when they can have those hearings remotely. Of course, there are some things that are better off in courtrooms, but they should be decided by what matters to the public and what makes a difference to the public, and not to the convenience of individuals who work in courts. But the answer is not only collecting the data to show it, although I think that's a really important part of the work. It's qualitative and quantitative information. The stories are important, right, in the meantime. And I hope that we can make sure that they're told, because as courts are considering whether to undo everything they've done or continue to move forward, there will be voices that want to undo everything and go back to the way it was because it was more convenient for some individuals. I don't know how other states operate. Michigan has been operating under a lot of emergency orders for the last 16 months that have allowed all of the remote participation. And we will be taking public input on a lot of those changes. But I believe that backsliding is the biggest risk we face right now, and the people who will pay the cost of that are the people we are supposed to serve. So rule changes have to be made permanent, rule changes that were emergencies, and presumptions like the one Justice Stevens talked about. In certain cases, there should be a presumption that can be rebutted if there's a litigant who can't access remotely, or, of course. But that's, I think, the important job of court leaders right now. And so for those of you who might have judges who are resistant, I hope you'll tell those stories, because you know them better than anybody else does, because they need to hear it.
Thanks, Chief. I'll just add one more piece of information and a resource to the comment about child welfare proceedings and understanding it from the user's perspective. We have just completed the first phase of a national virtual hearing evaluation of child protection, child welfare cases. It's across 5 states. We're in 17 jurisdictions. And it started really in full force at the beginning of the year. We conducted court observations in, I think, over 350 virtual proceedings. We conducted surveys of attorneys, of social workers. We interviewed parents, we interviewed youth, we interviewed all the judges presiding over those cases. So we have a really good mix of quantitative and qualitative data. We just released several kind of fact sheets and summaries and tools that describe our learnings and the findings. They're on the National Center's website. The next couple phases will dive a little deeper into, it was more of a process evaluation. We want to look at the outcomes. Are the outcomes different in these cases? I could talk on and on, but I'll stop. But I did want to mention that, and I think we can do similar. I mean, it's in a very discrete case type, but similar types of evaluations that we want to do. And if you're dying to know the findings, everyone was supportive of virtual proceedings, except one group. Anyone want to hazard a guess? The judges. The judges could not wait to get back to the courtroom, so there's some hurdles, but we learned a lot. One of the things we learned too is because there are lots of different types of proceedings in child welfare cases, maybe some of them are more appropriate for in-person or would really necessitate, at least in most circumstances, but then others. So that's one of the big questions. How do we determine, in looking at the data, what types of cases or what types of proceedings are appropriate for hybrid? I did want to mention that. Can't see, I'm blinded.
Good morning.
Kevin.
Chief Justice McCormack, you made some interesting comments that rung true to, I think, many of us here when you're talking about public trust and confidence in the courts. That's been a fundamental tenet of NACM for many, many years. It's one of our core competencies. And we try to focus on that, and yet those of us in the court management world have this tightrope that we're walking, where part of our jobs is to make judges successful, make judges happy, make judges good at what they do and get through their work. And as it's been suggested here already, many of those judges want to go back into the courtroom. So I think if there's anything that can be done either through CCJ or COSCA or through our individual Supreme Courts to, as you say, to have those rules that continue the emergency orders, continue the authority to work in ways that are going to be more accessible to the public that we're trying to serve, and then also anything that can be done in work with legislators to provide the resources that are necessary. I think many of us are willing to do more in terms of bringing accessibility to the public, but oftentimes that requires resources that we don't currently have. And especially for those of us that are funded at the local level, it's even more challenging at times to be able to get what we need to reach out to the public and to make that available. So I just encourage you and everyone that you're working with, if there's anything that can be done at the state level or national level advocacy to help us out with the resources we need, I think we're ready to move forward. We're ready to do what needs to be done, but we can't always do it with our hands tied behind our backs.
Absolutely. I will tell you that when we meet later this month, CCJ and COSCA are considering 2 resolutions, and one is for increased remote participation to increase access to justice. It has an access to justice foundation. I have every reason to believe they will be adopted. I certainly hope. I'm the one shepherding it, so we'll see. And the second one is process simplification for access to justice. So I think CCJ will be speaking with one voice, and COSCA, I should say, by the end of this month, which is usually helpful to take back to state legislatures and local funding units. And so I will be able to report back on that in a couple of weeks, but I'm optimistic about both. And as for resources, I couldn't agree more. And I've been saying for the last few months that court administration is infrastructure. Am I talking too long? Do you want me to shut up?
We're good.
Oh.
I just wanted to make sure.
Okay.
We got 10 minutes, so you're
Okay.
good.
All right. It seems like infrastructure to me, equity, access to justice, and frankly, we now know all of the things we could do better if we had some additional resources. So it's infrastructure, isn't it? There's some funding available right now, one-time funding, which is frankly a lot of what we could use to build some platforms and systems that could make a big difference in our communities. And I'm doing what I can to talk about that to the people who make those decisions in Michigan. And I know that the National Center has been trying to make that point in Washington as well. So maybe you could all keep talking about it that way too. It's infrastructure. When you talk to your local funding units, we have an infrastructure project for you.
You want this one, Kathy?
He's coming.
Okay.
So this question is from someone watching live stream. I am curious why there is not more conversation around the safety and integrity of court information. Many courts are not paperless. Courts safeguard their files with restricted access methods, both physical and technological, and now that idea seems to be cast aside in this push to turn processes into remote and encouraging case files to leave the court facility in order to allow employees to work from home. How is this not concerning? How do you ensure safeguarding of sensitive information inside someone's home or anywhere outside of the courthouse?
That's a great question. I can tell you about our process for when working remotely. Our employees are accessing the information remotely. So the court case management system doesn't leave, but they are accessing it through a private network. And, you know, to be honest, we can't control what's happening in the home. What we focus on is that the information is available so that the court continues to operate. And we put in the levels of security as per our funding unit's IT department to ensure that no one can access that information. There's also an agreement that we have our employees sign to ensure that they're keeping non-public information secured. They don't have access to lien. That's something that they had to go on site for, and so that was like one of the downfalls. But yeah, no, that's a great question, but you know, moving forward as we look at remote operations, those are the things that we have to consider because it's still out there. But again, the overarching goal is to make sure that the court continues to operate, because at least in Michigan, and according to that local newspaper's headline, we're preparing for the next time. And so we've had 16 months to figure this out. The next time it happens, we're going to come in as pro experts because we're testing all of those possibilities now.
Thank you. I also appreciate the question, and the issue of access to public records came up in the Monday afternoon session. And it reminds me of when we were, 10 years ago, really working on data exchange between the courts and different entities like social services and probation and service providers. And we had to engage in so much work taking a look at all of the legal frameworks and establishing, safe ways of exchanging information, of protecting documents. And it seems like that's going to be an effort that we're really going to need to be involved in going forward.
And I'll just mention one more resource that was produced and kind of sponsored by the Technology Working Group that Chief Justice McCormack co-chairs with David Slayton. But they really, during this past year, looked at cybersecurity issues. We've learned a lot. Several jurisdictions, including the state of Texas, were guinea pigs, so to speak. And there's a lot of guidance. There was a national webinar with some really great folks from the federal government. So I would encourage you to go access those resources on the NCSC website. And I'm holding the mic, but I don't expect to in about 3 minutes. So before I forget, I'm going to put in a plug for the Court Technology Conference, which is September 28th and 29th. If you appreciated what you've heard and are learning about the implementation labs and some of the efforts, one of the tracks at CTC is really focused on the labs and the topics and the work. So I would encourage you to look into attending. I think we have like 3 minutes if there are any other questions or any final remarks from any of our panelists.
Judge Stevens. I heard you talk about the Zoom access and it being an access to justice issue. It is very much a race equity issue.
I'm going to repeat what Judge Stevens said, that remote access is an access to justice issue, but it's also a race equity issue, and that's absolutely true. So I don't know what reasoning works best with the people you are working with. Try them all, but she's absolutely right.
Thank you for that comment. And one of the reasons for the virtual counter, or at least the goal and intent, was to be able to reach out into the public. And again, we tried to make the process simple for those with varying levels of comfort with the technology. And one of the things that and I learned about this in a session yesterday about now I can't remember the name of it, but it was the racial blueprint? I don't think it was blueprint, but it was an assessment that whenever you take on a project, you consider those factors whenever you take on the project. And that was something that I considered when implementing the virtual counter. Is this going to be accessible for those who need it? I knew we weren't going to capture everyone, but what I did know is that as far as a mobile everyone had a smartphone. And with Zoom, and if you made the instructions simple, and for us, we put it right on our website. We put that link right on our website, and then Zoom takes it from there. We were told that you didn't have to have an account, but if you did, Zoom was going to take you there to create the account. And like I said, when we beta tested this, when we kicked this off at the end of August, by then December, we had less than 500 calls for a 3-month period. And then from this last 6-month period, we're over, we're almost at 2,000 calls. And that's just because as it became word of mouth, more and more people were starting to get used to it. And so it's one of those field of dreams type situations. If you create it, they will come. And as courts, we really need to get out, and this is Nicole speaking for herself, get out behind the walls of the courthouse and meet our community where they are. And by having that remote option, Chief Justice talked about, those who have kids, who have daycare. For my situation, I have, students who can't miss their exams because they're so important. But, again, whatever the reason may be, having that option is helping people in whatever status, wherever they are, we're meeting them where they are. At least that is the hope.
All right, I think that wraps it up. Thank you to our panelists. Thank you to you all for your excellent questions. I think we're turning it over to Kathy.